case on this morning's docket. Case number 106586 and 106587, State v. Dunn.
Good morning, I'm Rick Kittle. I represent Mr. Dunn. I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
Based upon this court's order for additional briefing in this case, it appears the questions before the court are the purpose of a charging document and the effects of any defects in that charging document on the case and the court's authority. In answering the questions that were posed in the court's order, there's clearly a long history in this state that, even before Kansas was a state, that links the manner in which a charging document is drafted with the jurisdictional authority of the court. Of course, I'm referring to that Freeman case, which was decided even before Kansas was a state. There's a dual purpose in Kansas for the charging document. One purpose is constitutional. Kansas Bill of Rights says that the defendant must be advised of the nature and the cause of the action against him, and that's so that he might prepare a defense in the case. And Kansas statutory law, and I'm referring to KSA 223201, has indicated that the charging document must be a written instrument, that it must set forth the essential facts constituting the crime charged, and that it is sufficient if it's drawn in the language of the statute. And so, at least to my way of thinking, that serves that constitutional purpose of letting the defendant know what he's charged with. There's also, however, a jurisdictional purpose, and there are a number of Kansas cases that have stated that the complaint or the information is the jurisdictional document upon which the accused stands trial.
Mr. Kittle, there's no question we have a bunch of cases that say that, exactly what you just said. But do they also demand that each element be stated? In other words, I'm wondering if those two purposes you just outlined are really completely coextensive in terms of their demand for what's in the charging document.
I believe they are, Your Honor, because just as there is a statutory component for the constitutional question, there's also a statutory component for the jurisdictional question. If you look at KSA 215109, and of course that statute number is something that was created after the amendment to the criminal code in 2011, but even the precursor statute indicates that the accused may be convicted only of the crime charged or a lesser included offense of the crime charged. Now, the way of thinking about this is that the finder of fact in a criminal case, whether it's the jury or a judge in a bench trial, that's the entity that finds the defendant guilty or not guilty. That power of conviction is vested in the authority of the court only, and statutory law says that an accused may be convicted only of the crime charged or a lesser included offense of the crime charged. So there is a statutory linkage between that has the effect of limiting the authority of the court according to the crime charged.
That statute actually says crime charged or lesser included crime, but not both.
Right.
Which basically sets up that there are multiplicity for convicting of both a principal and a lesser. But we do have multiplicity being raised a number of times, and we consider that, determine if they were multiplicitous, and then rule on it, but we don't find that it was a jurisdictional problem, do we? We don't define, we define multiplicity as a double jeopardy issue rather than a jurisdictional.
But I think that, well, I suspect that might be because those multiplicity issues are not typically raised as a jurisdictional problem in the nature of Paul and its progeny. But recognizing that that statutory language, it does invoke questions of multiplicity, I'm asserting that it also has the effect of limiting the jurisdictional authority of the court when it comes to imposing a judgment of conviction, and that authority of judgment of conviction is vested in the jurisdictional authority of the court.
Let me move you to another question, Mr. Kittle. Is there a difference between deficient and fatally deficient? In our case law, does that distinction, if it exists, mean anything? And what about our cases, our recent Jessica's Law situations where we said you failed to charge 18 or over, but the proof was abundant, therefore we're going to call it good? How does all that fit? Are all those cases just wrong? That's a compound question. Appreciate, but if you can-
Complex question.
and complex.
I don't know that I can give a comprehensive answer to that, but
Let's start with the difference between deficient and fatally deficient, if there is one.
if you accept that there's a dual purpose to the charging document, I believe that there may be situations in which a charging document may have some sort of defects, but could be interpreted as not prejudicing a defendant to the extent that he was not able to understand the nature and the cause of the action against him.
In other words, purpose one is not defeated.
Right. But that same charging document may have the effect of eliminating the jurisdictional authority of the court because it doesn't sufficiently charge a crime. Now, if you recall what happened in this case, it was a forgery case. The defendant was originally charged with 8 different counts of forgery. 7 of those counts did not survive preliminary examination due to lack of proof. And the defendant only went to a bench trial on 1 count of forgery. That count of forgery, which he faced trial on, did not contain the language intent to defraud, which is an essential element of the crime of forgery. What the Court of Appeals said is, well, if you apply the Hall standard, if you apply this more lenient, more expansive interpretation of how you put a charging document together, we can take language from a different count of the charging document, a count which did contain the words intent to defraud, and use that language to plug in the gap that's found in the charge that he faced trial upon. I'm arguing that that runs contrary to Kansas constitutional law, because statutory law. Kansas statutory law says that you can do something like that, but you have to incorporate by reference language from one part of a charging document to use it in another part of a charging document. And that didn't happen here. There was no incorporation by reference. The second point is, this seems to run contrary to the purpose, one of the purposes of the charging document, to adequately inform the defendant of the nature of the cause against him. And it's really not a common sense solution, because at the point that an accused, in looking at what he's charged with, or what he thinks he may be charged with, has to take language from one part of a complaint and combine that with language from another part of a complaint, that's not a common sense solution. And at that point, it doesn't even serve to adequately inform the defendant of what he's charged with, because he has to do the work himself.
Did that happen here? Did the defendant not know that intent to defraud was part of what was a part
Well,
of
we
the crime?
haven't really made a claim, or it wasn't made the claim, well, there was no claim made below regarding the sufficiency of the charging document. The point being made here is that this is more of a jurisdictional.
I understand. Yeah.
I'd like to circle back to a question that Justice Breyer asked you, but I'm not sure I understood the answer or heard the answer. And that is why elements are jurisdictional under the statute. I understand that there has to be a crime charge, but why is not just informing the defendant you are charged with forgery under given the statutory reference? Why is that not sufficient to charge a crime? Why is then the listing of the elements a necessary part of jurisdiction?
Because in the statutory law, 223201 says that the complaint must be a written document, and it must set forth the essential facts constituting the crime.
Facts are different than elements.
I don't think they are. If if we're talking about what is essentially improving a crime, I think you would have to allege that the defendant did this with an intent to defraud, or whatever the crime might be. Say it was aggravated assault, that the defendant intentionally placed another person in reasonable fear of bodily harm while
Again.
armed with a deadly weapon.
Again, is that necessary for jurisdiction, or is it sufficient for everyone to know what transaction is being alleged to be the criminal act?
Well, if what you're saying is, could a charging document just say that the defendant is charged with forgery or any other crime and set forth the statutory number, I don't think that's sufficient, because that doesn't set forth the facts constituting the
No,
crime.
I'm not suggesting that, but if it had said that, you know, he committed forgery on X date by presenting this check to this merchant, that type of thing, but not necessarily use the specific element in the language, would there be jurisdiction?
I think there would be a jurisdictional problem, because that would not set forth all of the essential elements of the crime, and I don't think that would have set forth the essential facts of the crime either, if you assume that intent to defraud is one of the essential facts necessary to prove the case.
Because that isn't a crime. Taking someone else's check and writing it isn't a crime unless you have the
Right.
intent to
All of the
defraud.
elements have to be stated in order to assert what is a statutory crime.
I hate to be a broken record, but I want to go back to defective and fatally defective. When
Okay.
we restated that question, I think your response was that you can have a situation where the defendant, or certain defects do not defeat purpose one, where the defendant has adequate notice, but there's still a jurisdictional problem. So would such a complaint, in that hypothetical, be both defective and fatally defective?
Yes, I think so.
Fatally defective because of the jurisdictional problem.
Yes.
So do you think the term fatally defective should be applied only to when there's a jurisdictional problem, when purpose two is not served?
Well,
And do you think
Not-
that's
not
what we've
necess-
meant in our previous cases? Or do you think those terms have just been
well,
kind of bastardized over time?
yeah, I'm not sure about how to reconcile the meaning over time of those terms. I think a document could be, a charging document could be fatally defective because it omits an essential element, one or more, and therefore there's a jurisdictional problem. That same document could be fatally defective for a constitutional purpose because it doesn't adequately inform the defendant of what he's being charged with.
Well, let's take the Jessica Law case, and where the complaint did not state the defendant's age as being 18 or above. We've indicated that's an element of the crime. So that's defective only with regard to prosecuting the enhanced crime. But it's not fatally defective because it does charge a crime, just
Right.
not the one they intended.
Right.
And so, I mean, I can see a difference between having a defective charging document that does in fact charge a crime. So it
Right.
would not deprive the court of subject matter jurisdiction to proceed. It just would deprive the court of the authority to convict of the uncharged but intended crime.
Right, and I think that's the situation in the minor case that's cited in the briefs. You know, I think most of the time when you have an element omitted from a charging document, that charging document is not going to charge any crime because it doesn't set forth all of the elements. But in some cases, if the element missing is the element that makes the ostensibly charged crime an aggravated form of the crime, then it still might charge a lesser form of the crime. I think there's statutory language, and I'm sorry I'm out of time, so maybe I should just ask the court.
No,
Please
we would
finish.
like for you to stay here and answer all of our questions.
The statutory law says that a charging document is sufficient if it is drawn in the language of the statute. Now, there's a Hazen case that was relied upon by the state in its supplemental brief. Hazen basically says that charging document was okay because it was substantially in the language of the statute. But that's not what the current statute says. It says it's sufficient if it's drawn in the language of the statute. And I think that language has led prosecutors, when they draft charging documents, to just parrot back or try to parrot back all the language of the statute. I don't think a charging document has to be drafted in that way. I think a charging document could look more in the form of a jury instruction with enumerated elements that constitute all the facts of the crime. But prosecutors have chosen to use this just try to repeat the language of the statute, and mistakes have been made. The state in its brief has indicated that this might be a question of invited error, but I don't think this has ever been viewed as a problem of invited error. Even Hall says that these issues can be considered for the first time on appeal. Hall just says that the fulcrum of this is the motion to arrest judgment. We're going to apply one set of rules before, if there's a motion to arrest judgment filed, and we're going to apply a different set of rules if there is not.
And the problem with that, it doesn't fit within our other precedent dealing with jurisdiction. Even
Correct.
Subject matter jurisdiction, you can't have retroactive jurisdiction. You can't have a waiver of jurisdiction by failing to file a motion to arrest judgment. So that's what we're struggling with, whether this really is a subject matter jurisdiction problem, because the court obviously was the correct court to hear this criminal case. I mean, there was subject matter jurisdiction over the crime of forgery.
Right.
And what we're struggling with is, why does a missing element destroy that jurisdiction?
Because Kansas statutory law links the manner in which a charging document is drafted with the jurisdictional authority of the court to impose a judgment of conviction.
Can you talk briefly about the Cotton case?
Sure.
That's a hurdle for you, and I understand you don't think we should apply the rule in Cotton, right?
Right.
And just briefly expound on that.
Cotton was well, I don't know if I need to go into the background. Cotton basically overruled an old United States Supreme Court case, Ex parte versus Bain. Cotton held that a defective complaint does not deprive a court of jurisdiction. Bain was basically a situation in which some language was removed from an indictment, which the parties at the time thought was superfluous, but what it actually did was remove an essential element of the crime, and therefore the Bain court held at that point there was no longer any jurisdiction because the indictment didn't charge any offense. Cotton said no, that's not the case, but the basis for Cotton was that at the time of Bain, the United States Supreme Court authority to review criminal cases was severely limited. And according to the language of Cotton, at the time of Bain, a defendant could not obtain direct review of a conviction in the United States Supreme Court. And there were similar limitations on writs of habeas corpus, review of those. And that's what led to this, in Bain, this more expansive notion of jurisdiction so that the Supreme Court would have some sort of vehicle to review criminal cases, which it wouldn't otherwise have. I'm not aware of any similar limitation historically on this court's ability to review criminal cases. I think all one has to do is to go back and look at the reporters from the time of Bain or even before that, and there's always a number of criminal cases that got direct view to the Kansas Supreme Court. So the justification that the United States Supreme Court used in Cotton to overrule Bain is not present historically in the, if you look at the legal history of Kansas. And given this linkage, I believe in both statutory law and case law between the charging document and the jurisdictional authority of the court, given the long-standing history of finding that a conviction that's entered based upon a defective complaint is void, and given a long-standing history that goes back to the time of Civil War that says that a void judgment can be attacked or challenged at any time by anyone who's affected by the judgment, the justification of Cotton does not exist in this case. And in fact, there's a long history of Kansas case that says we should go in the other direction.
But we have a quarter of a century of Hall. Hall was a 1990 case.
Correct.
So that's 25 years ago. So if we overrule Hall, we're also changing long-standing
But
law.
I guess that's true. But I think the principles of law that I'm relying on are even more longstanding than Hall. And I think Hall was wrongly decided because it allows this quote-unquote common sense interpretation of a charging document that's not justified in Kansas statutory law. If the state wants to use one language from one part of a charging document and apply that to a different count in a charging document, Kansas statutory law requires them to do that again by incorporation by reference. And that makes sense because if someone reading that document would understand that, well, what's said here is also going to apply over here. But that's not the way it happened in this case. Mr. Dunn couldn't be expected to know in that the crime of forgery that he was facing trial on actually contained another element that wasn't present in it when he read it.
And so more liberal pleading requirements in the statute would change could change what is required in terms of giving us jurisdiction or giving it court jurisdiction.
Well, yeah, I mean, we could, yes, the legislature could change that statute, I suppose. And that very well may be the case of what happens depending upon what this court decides. But
So
the point is,
so it's not, can never be solely constitutional based under your argument. You have to have the linkage of the statute and the Constitution.
well, I don't know that you have to, but I certainly think that's what exists right now. That exists with Mr. Dunn's case, and it has for many years. The statute obviously could change. This all comes down to the problem of the prosecution. What the state has attempted to do in its brief is place the burden of its own errors on the shoulders of the accused and call this invited error. But it's the prosecutor's job to draft these charging documents. And they have been given the statutory benefit of unlimited opportunities to amend a complaint up until the time that the case goes to the verdict. They've got as many chances as they need to get it right. So under those circumstances, there's really no excuse for them not to get it right. And but if they don't get it right, the error caused by that, the constitutional error, the jurisdictional error, should not be placed upon the shoulders of the accused because it's not the accused's fault. Similarly, there's case law that says a court has a duty on its own motion to notice jurisdictional defects. So this is not Mr. Dunn's problem. It's a problem of drafting the charging document. That was recognized in Hall. It's just that Hall said, okay, from this point on, we're going to have two different ways of looking at this depending upon where there's a motion to rest judgment from. And I think that may exhaust my comments unless the court has another question.
What would be the latest that this point can be raised by your client? In other words, that the complaint was defective, fatally defective.
If a fatally defective complaint deprives the court of jurisdiction to enter a judgment of conviction, and if the rule of law, the long-standing rule of law says that such convictions are void, and if the other long-standing rule of law that says a void judgment can be attacked at any time, I don't think there's any limit to when these judgments could be attacked. And you see that in the O'Keefe case that is cited in the supplemental brief, where the challenge to the jurisdiction came, I think, 11 years after the judgment of conviction was entered.
That would be your position.
Yes.
Any further questions? Thank you, counsel.
May it please the court. I will try and be very brief.
Maybe we can speed things up for you.
Okay.
It seems to me that in your brief, you just equate notice to the defendant, in other words, purpose 1 as outlined by your opposing counsel, with purpose 2, jurisdictional sufficiency.
Well,
You
I
think they're
that,
completely coextensive?
I think that is essentially the point that Hall was trying to get to. I think that's the point that Cotton was trying to get to. If I understand your question correctly, so long as the person is on notice of the crime for which they are accused of, it might be a defective charging document, but that doesn't mean that it's fatally defective. The question is, when does it become fatally defective? If the legislature has given the prosecutor unlimited ability to rectify the problem up until the verdict is handed down, then it's not fatally defective at any point in time during the jury trial, the state would argue. It would have to be after that it's fatally defective. And the state would argue that in order to be fatally defective, the charging document, the defendant can't know what he's charged with. Such was the case with Minor, where he was accused of, I believe, manslaughter in the fourth, but he was charged with manslaughter in the fourth, but he was convicted of manslaughter in the first.
What was he charged, what was Mr. Dunn charged with?
Mr. Dunn was charged with a number of crimes. One of those was forgery.
And without an intent to defraud, is that a crime? The physical acts he did, if he lacked the specific intent required, did he commit that crime?
No.
And so the complaint did not actually charge a crime.
Correct. Well, yes, that is true. It did not actually charge a crime. However, there is case law that said that some words are so well known that they, I believe there was a case, it could have been Klassen, where it said that the word basically spoke for itself. It had been, it had taken on its own meaning, and everyone knew what it meant. It is a common everyday meaning.
And the word here that you rely on for that is just the word forgery?
Well, forgery in that it was fraudulently done.
Is forgery the word you rely on?
Yes. Yes, Your Honor. So the question is, as in Cotton, what is the real question? The question is whether or not justice would be done if they were to dismiss that case.
But isn't part of justice following due process and giving adequate notice to the defendant and having jurisdiction in the court that prosecutes him or her?
Yeah, that is absolutely. And the question is, did Mr. Dunn have adequate notice? Mr. Dunn put on a defense that he was not defrauding. I mean, he put on a defense for that very element. That element was charged. There was proof put on during the trial that he had defrauded. So he knew what he was being charged with. He knew what he was being accused of, and he put a defense on.
The defense, I was going to say, the defense was that Shaw had given him permission to use her checks.
Correct. Correct.
So you were saying that what happened here was correct because forgery has a plain meaning that includes an intent to defraud. So the complaint, or excuse me, not the complaint, let's talk a little bit more specifically, the particular count with which we're concerned. In spite of omitting the element of intent to defraud, you're saying it implicitly included it by having the word forgery.
It could have, yes.
Well, did it? Is that your position?
I don't know. I don't know how the defense came up with his argument against with the intent to defraud, but he obviously did come up with a defense with the intent to defraud.
Okay, I understand that point, but I'm just trying to get, before the defendant does anything, was the count sufficient to charge a crime of forgery or not? I thought I heard you say earlier it was not. Then I figured you were relying on the Court of Appeals borrowing from a count that he was not bound over on. But I'm just trying to understand your position. Does it or does it not charge forgery sufficiently for any purpose?
No, I don't believe that it sufficiently charges, but I believe...
So it didn't really mean that forgery includes intent to defraud. You think that the Court of Appeals needed to borrow from one of the counts that he was not bound over on?
In order to show that he knew what he was being charged with, yes, I believe that they would have to borrow from the document.
Okay, thank you. I was just confused.
If this had gone to a jury trial, the jury would have been instructed, normally is instructed, you are to look at each count individually without concern for your decision on any other count. So I'm having a little trouble here if we state for the jury that the law is that each count is standalone without regard to the others, why we expect defendants then to pick pieces and parts out of different counts. Do you understand what I'm trying to ask you?
Yes.
If they stand alone, then how can we say that you intuitively know that you're supposed to incorporate by reference?
Well, I don't know that the defendant is supposed to incorporate. And I think that's where it would come down to whether the charging document is fatally flawed. If, through the evidence of the trial, it appears that he didn't know what he was charged with, there wasn't mounting the appropriate defense, then the Court of Appeals could find, listen, he just didn't know what he was being charged with. But I think the jury would never see the charging document anyways. The jury would only see the jury instructions. And in this case, we don't have that situation where they had the jury instructions.
The problem I'm having with that argument is that you know that the count was okay when it goes to trial, and you look at the defense, is that's like jurisdiction is supposed to exist when you commence the action, not arise later. And that's what I've always had problems with Hall, is that it's a retroactive jurisdiction when you waive your objection by not following a motion to arrest, whereas jurisdiction either is there or not. You don't have a little bit of jurisdiction. And so if we have to wait to look at how the defendant acts at trial, I think that's too late to be looking for jurisdiction.
But the statute allows the charging document to be amended at any time up until verdict. So even after the trial is essentially over and all evidence has been presented, the legislature has still granted the state abilities to amend that, which would I assume would grant jurisdiction. It would fix the problem. But the question would still be, this is all going to be case specific, but the situation would still be, did the defendant know what he was to be charged with? Is he able to mount a defense? Is he on sufficient notice? I believe that the charging document can be flawed, not fatally flawed or fatally defective. But it all comes down to, was the defendant on notice? Was he able to provide a defense for what he is charged with? Does he know what he's being charged with? And I think what the defense is saying is, every essential element or every element has to be on the charging document. And if it's not, then the case is void and the case has to be thrown out. I don't know how that comes to judicial economy. If this case is thrown out, then we go back and we recharge him, because if there was no jurisdiction, there's no double jeopardy. So we have to do the whole thing over again to fix one word. If
We don't really entertain your judicial economy arguments on jurisdiction, do we? I mean, jurisdiction is jurisdiction is jurisdiction, as my colleague suggests. Can't be a little bit jurisdiction. You can't have a little bit of jurisdiction or be a little bit pregnant, right?
I agree. The question is whether or not when does jurisdiction vest, or when is jurisdiction granted to the court? If the statute allows for jurisdiction, if the statute allows for the charging document to be amended at any time, the question is, would jurisdiction vest if the state had amended the charging document 15 minutes before the judge handed down his finding? And if it does, if that would have fixed the problem, then it would have been a sufficient charging document.
Go ahead.
Were you going to talk about Cotton in any great detail today?
I was going to talk about what I see as the underlying theme, which is that justice was to be served, and that the justice was to, I believe it says, the real threat then to fairness, integrity, and public reputation of judicial proceedings would be if respondents, despite the overwhelming and uncontroverted evidence that they were involved in a vast drug conspiracy, were to receive a sentence prescribed for those committing less substantial drug offenses because of an error that was never objected to at trial. Mr. Dunn never objected to anything at trial. Paul specifically finds that the correct remedy would be the motion to arrest judgment, which would have been afterwards.
But Cotton got to that point by saying the defect is not jurisdictional, correct?
Correct.
And Hall seems to have gotten to a similar point by saying it is jurisdictional. Can you address what appears to be some various opinions on that subject?
Well, I don't know how intelligently I can speak about the United States Supreme Court and the way they got to their decision. I would assume that both this Kansas Supreme Court and the United States Supreme Court got to the same underlying factor, which was this was in the best interest of justice, and they did it through two different routes.
Which we call being result-oriented.
Okay.
Picking a result and then justifying it or rationalizing it, rather than following the law to its destination. And we generally try to do the latter rather than the former. So it doesn't help us to just pound the table and say justice. We need to understand the sensibility of the rationale. And that's what my colleague was trying to ask you about. The Cotton Court got there by saying it's not jurisdictional. The Hall Court got to its result by saying it is jurisdictional, but we're just going to forgive it in certain circumstances.
Well,
So which train are you on?
I think I'm on the Hall train. I believe that Hall takes in and said the underlying theme that I would take from Hall is that if the defendant is on notice, then jurisdiction has applied. The court has jurisdiction. It is a sufficient charging document. It may be missing some things, and if it is if it is objected to during trial, then you use the pre-Hall standard, and if it's if it is appealed, or this issue is brought up for the first time on appeal, the issue of I just didn't know what I was charged with, as was the case in Mr. Dunn until many months after the decision, this court has basically said, we're going to see that it was sufficient. If you didn't know what you were being charged with, that's something that you should probably bring up during trial and not months afterwards. So I would be in agreement with Hall. I don't know that I think that Cotton is federal law, obviously, but it's not something that this court has to take into consideration or do. But I would consider myself for the sit on Hall.
I think I'm hearing you say that you're acknowledging that Cotton is at best persuasive authority for us.
Well, I know that Hawaii in Apalimi did not find that.
Well, we're talking about jurisdiction in a Kansas
Right.
court for a Kansas crime and a Kansas defendant, and whatever Cotton determined about federal law and federal courts is not binding
Correct.
on what is jurisdiction.
Right. I would believe that it is persuasive, but that would be the best.
It would be on notice because those are Fifth and Sixth Amendment based, but not on jurisdiction. But you're equating the two. So anyway, we'll try to
Well,
unravel it.
But I think that's what the case law has essentially said, is that if the defendant is on notice, then it's sufficient. And that's a sufficient charging document, which it gives the jurisdiction.
But Kansas hasn't always said that.
Well, I think it has. I think Kansas said up until the late 70s and early 80s, which is what led to Hall. Before then, there were many cases that said, we will find that it is sufficient, that the defense was on notice, even though there was an essential element that was left out, intent to defraud. Things of that nature have been left out of several cases, and the Supreme Court has said it's still sufficient. For one reason or another, it's still a sufficient document because the defendant was on notice.
Mr. Jones, I know you're not a spokesperson for all prosecutors across the state, but what is your best understanding as to why we keep confronting this problem? I mean, in a way, Hall was a response to the frequency of cases that came up with missing elements or not putting the proper charging in the context it was meant to be. Cotton is the same way. Why does this happen? I mean, Mr. Kittle pointed out you have ample opportunity. Not only do you charge, you pick the charge, you pick which elements you're going to choose under the specific charges. You have ample opportunity up until verdict to see that. And we're confronting this once again. What's your understanding of why this happens?
You mean the underlying problem as to why an element might be left out?
Yeah, I mean, it's not like it's rocket science.
Right. Well, I can only speak for the county that I represent. I'm assuming it's a very small county. We do about 350 cases a year, but I know there are much larger counties that do many more than that. The legislature keeps changing the statutes in some instances, but it's normally done by a program that you type in the charge and it comes up. And if the program is incorrect, or if the legal assistant doesn't put it in correctly, or gives it to the attorney who signs off on it, it could be oversight, it could be a charging of a defect with the computer, it could just be overworked offices. I don't know. I don't know why this one was left out.
I guess you can only speak to this specific one, but it's
I think
frustrating to see the frequency of this issue.
Right, and I think I agree with Mr. Kittle that the state needs to do a better job of making sure that those essential elements are in there, and I can't explain why all of them are left out. I believe it's a confluence of many different reasons as to why it might be left out.
This may be an unfair question, but I'll ask it anyway. Given that the state has the burden to draft these charging documents, does the rule of lenity come into play anywhere? When we construe statutes or penal statutes, we apply the rule of lenity to give the defendant the benefit of the doubt. Does if there's ambiguity here, like you said, certain words are commonly known. If that's questionable, does the rule of lenity kick in, or does it only apply to statutory construction?
Let me just make sure I understand your question correctly. Because the state is the one that's coming up with the charging document, if it's defective, is the state the one that should pay the price?
If there's any question as to whether a reasonable person should understand what it's trying to say, that's construed against the state.
Well, I think that is. I think that's essentially what happens. And if it was fatally flawed, that would be the case. It would be held against the state. They didn't put in the proper verbiage. But the state would argue if the defendant is on notice, then it's sufficient to vest that jurisdiction.
A different, rather, maybe not better, but a different analog would be the contracts construed against the
Right.
drafter type situation, because really rule of lenity is statutory interpretation and construction canon. Thank you.
You're welcome. Thank you.
Any more questions? Thank you, counsel.
I think one of the main differences between our position and the state's position is reviewing the charging document as having a dual purpose, and they're trying to meld this into one thing. So I guess to address that, what I'd like to do is look at Hall and take it to perhaps its a logical conclusion. Say you had a charging document that just had a list of different elements of crimes, dozens of them, taken from forgery, from homicides, from property crimes. There's just a list of elements there. And if you look at that list of dozens of elements, you would find all of the elements of forgery somewhere in there. So under Hall, there wouldn't be any jurisdictional problem with that charging document because it contained all of the essential elements of the crime of forgery. But I don't think anyone could say that based upon that list of dozens of elements, that the defendant would be adequately informed of the nature of the charge against him. So in that circumstance, you see the dichotomy between the jurisdictional purpose of the charging document and the constitutional purpose of the charging document to inform the defendant of the nature of and cause of the action against him. That's why we have these two things. That's why I'm saying that, we could have a charging document that might be sufficient for one purpose, but not sufficient for the other. And even if it's not a reversible error, rise to the level of reversible error on one count, it might rise to the level of reversible error for the other reason.
Actually void. for the
Right,
others.
void. And so I need to vacate that.
Right, so you're different, you have that tension as well. For the notice provision, you can have harmlessness, but you can't for the lack of jurisdiction.
entertain any questions the court.
Any more questions?
One question. If we agree with you that Hall can't or shouldn't survive its own sort of internal inconsistencies, but we are also persuaded, let's say, by Cotton, we find that this complaint was not jurisdictionally defective. Is there any other pathway that Mr. Dunn has to prevail in this case? In other words, at some point, are you pinning your argument on the fact that this complaint is jurisdictionally defective? And that's the only way forward for Mr. Dunn.
Well, I suppose I don't know that we necessarily did. I suppose we could have made more of a constitutional issue.
But in the procedural posture of this case, it seems to me that the lack of jurisdiction is very important for Mr. Dunn.
Correct, and that's what we've advanced here. And, you know, in the original brief, when I first looked at this case, I saw, well, that count doesn't contain that element. We're also arguing that there are other elements regarding lack of authority that should have been included in that count that aren't there. But knowing that Paul is the 500-pound gorilla in the room for a criminal defendant, you raise those types of issues, and, you know, for the past, 25 years, that's what shot us down.
Yeah, that's kind of my question. You might win the battle on Hall, but lose the war potentially. Is that a fair characterization?
That's possible, and, you know, it's also possible that based upon the outcome of this case, the legislature may choose to do something different with its language on jurisdiction, statutory language on jurisdiction, yes.
And that's because the constitutional component is subject to harmless error.
That's part of it, and that's one of the reasons why I think there are two separate things here. You know, the constitutional issue, the measure of error there is based upon the level of prejudice attaching to the defendant, but the jurisdictional question is something separate. It has nothing to do with prejudice to the defendant unless you're saying the prejudice of having someone subject to avoid judgment. But otherwise, it's just a question of the initial authority of the court to act in a particular case. And so that's why there is a difference in these two purposes of the charging document, too.
Before you sit down, would you address opposing counsel's comment about the ability of the prosecutor to amend after the evidence is all in?
Well, I think the language, I think that the controlling law indicates that statute means that the state can amend the complaint up until the time of verdict, so long as no new or different crime is charged. So if you were just maybe charging a different form of the same crime, that might be something you could do. If you were just amending a charging document to change a name or, you know, correct some sort of typographical error, that of course would be allowed. But if it's something that is new or different, which a felony that would allow the defendant to have a probable cause hearing, which he never had on that crime, that's the kind of amendment that could not be allowed.
So
But
if you, go ahead.
I would say, under those circumstances, is it possible that the defendant was defending himself or herself on a particular charge throughout the trial, and then when the evidence is all in, the prosecutor was allowed to change things?
Sure, I think that's probably happened in certain circumstances. And I don't know that that's necessarily the case here, but I think that certainly could occur in some cases.
And it's,
That was the essence of Attila, really.
Right.
That they switched the game.
so is that a constitutional issue or jurisdictional?
That strikes me off the top of my head as more of a constitutional issue of the defendant not really being adequately informed of what he's charged with. That charging document still may contain all of the essential elements of the crime so as to give the court jurisdiction.
That covers my
Any more questions?
Well, I want to nail this down. Are you saying that the state can or cannot do an 11th hour amendment to create jurisdiction at the end of the trial? If we would say that this is jurisdictionally deficient for failing to set forth the specific intent required, could the state have, after all the evidences came in, moved to amend to add that with intent to defraud language to the complaint and retroactively create the jurisdiction of the court?
I think well, according to statutory law, they can amend it at any time up until the case goes to the verdict. That might have the effect of completing all of the elements of the crime. I don't know that that's such a matter of retroactively. That strikes me as more of a question of, well, I've been proceeding on trial thinking this one thing, what I was charged with, and now they're changing the game. And so,
I think the answer to my colleague's question may lie in the source of the law for jurisdiction. And I think what your entire argument today has been based on the idea that the statutes define jurisdiction in Kansas, correct? They
Well,
define
yeah,
it
the
because
jurisdiction-
you said if the legislature changes the statute, then that could end up torpedoing defendants in a new way in future cases.
yeah, and I think that's correct.
So if the statute's the basis of jurisdiction and the statutes say we can amend certain types of complaints up until verdict, then.
Well, I think
statute
that
controls.
would be allowed. I don't know that that still might necessarily present some sort of an error which the defendant could raise on appeal.
But then you're talking about notice again, and we're back in constitution land, not in statutory.
Okay, I see what you're saying.
I'm trying to just preserve this
Right.
dichotomy that you've been arguing.
Yes, and I think that's true. And I think that goes back to the example when I first got up on rebuttal, that shows you can have relief on one, but not necessarily on the other.
Unless you
I-
can make the argument that a complaint that charges no crime and is amended to charge a crime has charged a different crime. Because you went from no crime to a crime. Because the
Well,
statute specifically says you can't charge a new crime or a different crime.
Yeah, I hadn't thought of it in that way.
There are
but-
arguments to make.
Right.
Well, I think Justice Johnson's touched on, I thought when you were answering Justice Ness's question, you were basically saying that the court had to have jurisdiction. But once the court acquired jurisdiction over a crime, then it could be amended to, but now I take it you're saying
Well, no,
that there could be an amendment that would cure a jurisdictional problem.
No, maybe I misspoke, but what you said first is what my thinking on this. Even though the statute allows amendment, may allow an 11th hour amendment, I'm not sure that necessarily cures a jurisdictional problem.
That just
Especially if it-
expands jurisdiction, is what you're saying.
Pardon me?
That just expands the jurisdiction that existed for the crime that had been charged and the jury heard the evidence? Is that what you're saying?
Well, I'm assuming that up until the time of the amendment, there was no crime charged because there was a missing element. And, as Justice Johnson said, I don't know, does that mean that there is a new crime being charged when there hadn't been one charged to begin with, and now, because of the amendment, there is one being charged? That would seem to be a new crime.
Any further
I'm not sure I
questions?
articulated that very well, but.
Well, I think there are multiple scenarios we could give you, and the answers might be different. And I'm not sure we defined the parameters of the hypothetical before we asked you to answer it, so it could have been a little unfair.
Your grimace a minute ago reminded me of the old adage that appellate lawyers have 3 cases on appeal: the one they practiced, the one they actually gave, and the one later that night that they wished they did.
Yes, I'll be driving back to Lawrence thinking of what I should say.
All right. Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.